Linda Clark, who is Emerita Professor of History at Millersville University of Pennsylvania, will be providing the comment. Her most recent books include Women in Achievement in 19th Century Europe and The Rise of Professional Women in France, Gender and Public Administration. And she's currently working on Women in the Politics of Education in Third Republic France, The Roles of Normal School Directrice.
Thank you, Sarah, for the introduction. It's a pleasure to have the chance to comment on the three fine papers in this session. Apart from their individual merits, they also well complement each other. And they remind us that feminism was, and still remains, a complex topic with more dimensions than in a dictionary definition of it as the theory of the political, economic, and social equality of the sexes. All three papers tell us about multiple strands of feminist argumentation. They present some individual participants in discussions of feminism during the decade after 1900 and reveal that often participants were neither totally for nor totally against a particular position. Charles Turgeon, a professor at the Faculty of Law of the University of Rennes, presented a number of complex arguments about feminism, and because of that complexity, and for the sake of chronological order, I'll begin with Karen's analysis of his weighty 2 volumes on Le Feminisme Français, published in 1902. Incidentally, now it can be read now on Gallica, if you want the 1,000 pages.
All 1,000 pages.
As I read Karen's paper, I wondered just how well Turgeon himself managed to keep clear in his head the various categories of feminism he laid out. The 3-part left, center, right, the 4-part bourgeois, worldly, professional, and worker, and the 7-part breakdown of issues into the intellectual, pedagogical, economic, electoral, civil, conjugal, and maternal. Karen's paper helps us understand what is most important to take away from Turgeon's nearly 1,000 pages. Surprisingly, at least to me, given the long history of French politicians' resistance to women's suffrage, Turgeon turns out to be its advocate. A few years before a bill to let women vote in municipal elections reached the Chamber of Deputies. While he spoke often about the equality of the sexes, especially in terms of religious doctrine, Turgeon was far more concerned about what he saw as the potentially negative effects of feminism on society and on families. Reacting to the reality that larger numbers of women after 1900 were becoming better educated than previously, Turgeon worried that they might turn into femmes savantes or bas bleu, who would lose essential feminine qualities and assume virile characteristics. Indeed, the fact that some women now wanted to enter traditionally masculine professions like law and medicine seemed to him to demonstrate what happens if too much education starts to denature women. He recognized that economic necessity dictated that some women had to work, but he did not want them in occupations where they competed directly with men. Also highly revealing about Turgeon's masculine bias were his fears about the impact feminism could have within the family. He found it natural that in the marital relationship, women yield to men, as the famous Article 213 of the Napoleonic Civil Code required. To avoid conflict between spouses, the wife had to let the husband take the lead. In the final section of her paper, Karen addresses the reception of Turgeon's book, which won plaudits from the Catholic feminist Marie Mougeret and respectful attention from the Protestant feminist Marie d'Abbadie-Deraste, one of the leaders of the recently founded Conseil National des Femmes Françaises. Abbadie-Deraste's review in the Protestant women's journal, La Femme, took note of Turgeon's resistance to women entering the liberal professions and his view that the court should remain a masculine preserve. But she also termed the book excellent and advised reading it to learn more about feminist arguments and refine one's own opinions. I know that time constraints did not permit Karen to add more to the reception section of her paper. And I see that noting Émile Faguet's review provides a telling reaction from a man more or less a feminist, that is, someone who thought that women had a right to work, but having the right did not mean that they should. Yet I could not help but wish to know what someone in La Fronde might have said. Did other feminists write about Turgeon? And were they as sympathetic as, say, Faguet? Karen's treatment of Turgeon today offers a hint about the riches awaiting readers of her just-released volume on feminism in the Third Republic up to 1920. And her summary of the many topics Turgeon identified well confirms her contention that by 1920, all of the essential feminist issues were, as she puts it, quote, on the table. The issues were there for debate, yes, although for later generations in the 20th century, some issues, such as reproductive freedom and discrimination in the workplace, would loom larger than they had before 1920. After all, even in the 1960s in the United States, help-wanted ads in newspapers still classified some jobs at employers' request by gender or by race. Now turning to Sarah's paper, which begins 3 years after Turgeon's book appeared. Sarah presents feminists who advocated not only in print, but also with a kind of public action. The Bellion sisters went to criminal court proceedings, thus appearing in public in a space long presumed to be a masculine preserve, unless a woman was the defendant. And the sisters then presented their judgments and those of volunteer all-women juries about the verdicts reached by all-male juries. Entering a space where Turgeon did not think they belonged, the sisters voiced concerns that included the double standard of sexual morality that is also central to Jean's paper. Before and after women lawyers were admitted to the bar in 1900, women like Jean Chauvin and Maria Véron were insistent advocates of the need to change many laws that disadvantaged women. Sarah's paper displays her impressive familiarity with the work of the first generations of women lawyers, as she focuses here on the specific debate about whether women should sit on criminal juries. One striking feature of this debate is the divide among feminists between those who called for mixed juries, men and women, with or without equal numbers for each sex, and those who favored all women juries to try certain cases involving women defendants, notably cases of abortion and infanticide. As with many other specific feminist issues, such as women's access to higher level administrative posts that I've looked at, opponents' arguments against change often cited women's lack of the vote or military service as disqualifiers. With the argumentation in favor of women jurors, we have another example of the common tension in early 20th century feminist discourse. Namely, the argument on the one hand that women should be jurors because as women they could judge other women more fairly than could men, or on the other hand, the argument that women should be jurors because they are men's equals in intelligence and judgment. Although Joan Scott considered French feminists' mixture of arguments citing gender equality and gender difference to be evidence of a continuing and problematical paradox in feminist thought, many French feminists, reaching for useful and persuasive arguments, simply embraced the notion that there could be equality in difference. Now, finally, with Jean's paper, we reach a moment in 1909 when Jane Mime, the editor of La Française, a feminist paper launched in 1906, decided to feature the question of the single standard or double standard of sexual morality, an issue which she termed the least understood of all feminist positions. In French law, the double standard prevailed, as both Jean and Sarah note. There were heavier penalties for adultery when the offender was female rather than male, and the law imposed more responsibilities on single mothers than on single fathers. To highlight the unfairness of the double standard, a problem already preoccupying feminists of previous decades, Mime surveyed 16 public personalities, 13 women and 3 men. In citing some of their responses, Jean focuses particularly on Colette Yver and Mime herself. Mime divided respondents into indulgents, who would forgive men's sexual misdeeds, and intransigents, who wanted a single standard of sexual morality and would not forgive misdeeds unless both sexes could be forgiven. Colette Yver was the well-known author of New Woman novels like Les Princesses de Science, published in 1907, and Les Dames du Palais, a novel about women lawyers that appeared just before Mime's survey. Mime criticized the latter novel for its caricaturing of feminists, but most other contemporary reviewers liked the fact that the novel was essentially anti-feminist, with its condemnations of not only a feminist lawyer, but also by extension, women's professional ambitions, which they perceived, like Turgeon, to be disruptive and harmful to families. Why then have several recent women literary historians, 3 named in Jean's text and a 4th in a footnote, insisted on terming Yver a feminist novelist? The essence of their argument is that Yver depicts women choosing professions and then struggling with the real difficulties that their choice posed. Certainly Yver's scenarios, delineating the problems of combining work and family, are often realistic, or at least partly realistic. But I find her conclusions about professional women so dismaying that I personally have trouble calling her a feminist. What is important to note here, however, for an examination of pre-1914 opinions about feminism, is that most reviewers in 1909, as Jean indicates, liked Yver's moralizing judgments. For my own research on women in education, I would also add that discussions of the problems of combining work and family were ubiquitous in educational literature. Typically, women educators said that most women desired marriage and motherhood, their natural destiny, but because many women who taught were also married and mothers, they did not usually assume that married women should bow out of the workforce. Among women educators, as among women lawyers, there were many nuances of opinion. One example, a woman normal school director who published an advice book for women teachers in 1907 insisted that young women should first be educated for their own sake as rational beings, because only after that could they function well as the traditional nurturers of others. To conclude, today's 3 fine papers reconfirm the complex nature of debates over what does or does not equal a feminist position a century ago as well as today. Thank you.
Questions? Comments?
A very general question about the right to vote and what its changing significance is in French political culture in general around the time you're giving your paper. So it's a question anyone could speak to. So, but I'll start to try to frame the question with more precision with respect to the jury. So it's not surprising that women began to serve on juries after they acquired the right to vote, because what jurors do is vote, ultimately. And it is arguably first and foremost a voting right. So while one can argue that the accused can't get a fair trial without women on the jury, that's actually a relatively weak argument, as it would be for me to say that because I'm Jewish and it affects the way I think about legal and moral issues, I have a right to have Jews on the jury. I mean, sociologically speaking, it may be a very powerful argument, but legally speaking, it questions the notion of objective deliberation by citizens. So it kind of piggybacks on the voting right. And then it was interesting that Turgeon envisions women voting, but then he sees the marital relationship as something not to be equalized, which presumes that that's not something you vote on, that there are whole areas of French law that are not subject to the vote. And finally, I want to throw in the pot something about our own constitutional system that's not particularly well known, which is there is no right to vote in the United States. There's no part of the Constitution that declares a universal suffrage. Rather, the 15th and 19th Amendments say that if you give the vote, say, universally to white adults, then you can't discriminate against blacks, and similarly in the 19th with women. But there's no right to vote per se, so any of our states could implement a property qualification, for example, which would limit the right of many people to vote, but they couldn't tack on additional race and gender distinctions. So it's not clear to me how important the right to vote is in general in democratic political culture, but and so I'm wondering if those espousing, rights for women had to simultaneously accentuate the importance of the right to vote, or whether it was gaining in significance anyways because men had an interest in it, if there was contestation over how important voting rights are per se.
Long answer, but do you want to go?
Oh, no, go.
All right. Well, I will say that in the book I'm writing on men and women as public intellectuals, I have 4 cases on work, on marriage, on prostitution, and on the vote. So one of the things I can tell you about 1909 is that it is a time when the male speakers of the Third Republic are in the middle of a giant fight about proportional representation versus voting by list versus voting by arrondissement. So this is actually a moment when male electors and male politicians themselves are debating the way in which to organize voting. And as I think Sarah alluded to in her paper, it's also a moment where Conseil de Prud'homme, which are councils that would adjudicate workers' complaints against employers, have recently been expanded to include women. I don't think they have all women Conseil de Prud'homme, but they have mixed Conseil de Prud'homme, which the include women as well as men. So this is a moment when the question of what voting means is coming up in a lot of different contexts, and I think one of the things that's interesting about Sarah's paper in particular, and all her other great work on women's legal history and history of women lawyers, is the way in which she shows how consistently people tie those two questions together, the question of citizenship, the question of jury service, the question of being a lawyer, and the question of being a judge, that those are all tied together in people's minds much more closely than the question of being a doctor and being a juror, or the question of being a teacher and being a judge, or the question of being a professional and being a citizen. Those 4 really come up.
Can I just add to that 2 things really in response to Dan's question. I think Rene Viviani, who was an attorney in his own right, a feminist, and eventually prime minister during the First World War, put it in this way in 1900. Basically, the legislators are made by the people who elect them, and the legislators will do what their constituency says they want to. The corollary that he said that at the Women's Rights Convention. And it's absolutely true. And what the French feminists were finding in all of their campaigns, they had many issues, but they couldn't get the attention of the parliament. It worked a little differently in a place like the United States, where the laws on voting, who could vote, and the procedures were all at the state level, not at the national level. And the same thing for family law. But in France, it was all being done at the top. So the Chamber of Deputies and the Senate were the citadels for action. And this is why the vote was so important. They finally figured out that there was no other way that they could influence these legislators if they didn't have the vote. The other thing with regard to the family, I think it was very, very perceptive to notice how the arguments were shifting. One of the things that's really interesting about Turgeon and any number of the other, especially Catholic commentators, is that they have this single view of the family. The family is hierarchical. These women, the wives, are supposed to subordinate themselves to husbands, and the law ensures in various ways that that's going to happen. But in fact, there were a lot of different ways of looking at the family already available in French culture. And in my book, I talk about 6 of them that were floating around in the 1880s. So this was one view, the hierarchical model. There were other people who were discussing partnership models. They were discussing, union libre, for free union, and there are a variety of other combinations and permutations on that theme. So to talk about the family in the French history, you really got to unpack what family is being talked about at any given time and by whom, because it's muddier water than you think.
No, I just wanted to make a quick comment. Unfortunately, Helen Shinnou is not here today. She's in Paris, but is just about to publish an article on precisely this question of attitudes of male elites in 1911 and 12 towards women's suffrage. It's absolutely fascinating and underlines many of the points that you've made, that the panel has made, about the extraordinary variety of arguments, complexity of whether, and the difficulty of identifying whether an individual is a feminist or not. It's just amazingly complex as I see it. But she also points out the number of these guys who seem not to even have thought about the question very much. This seem bewildered by the question and are kind of grappling for the first time over this issue of whether women should vote or not. So I think we will look forward to her article coming out later this year in French Historical Studies.
Yes, and I would add to that I know that Helen and I have shared for a long time an interest in these prud'hommes and prudes femmes, and I'm hoping that now that she has finished the suffrage article, that there will be a prude femme article in the works sometime soon.
I guess this is directed mostly to Sarah, but maybe it's for everybody. I'm wondering, you mentioned that there was an increase in crimes of passion during this period, and maybe obviously abortion and infanticide. I'm wondering whether the nature of the crimes coming before criminal courts actually pushed these debates in any way. Is there a notion that these things are becoming much more, prominent, and that people think it's acceptable to go to criminal courts to bring cases that maybe they wouldn't have in earlier times?
That's a good question. It looks like, Jean, you have an answer to that?
I do have a thought. I
yeah.
mean, this is a moment when I so wish that Rachel Fuchs were here.
Right.
Because of one of the things she shows in her great book on contested paternity is that although it's true that law could not be officially changed without the will of Parliament, law could be unofficially changed in the hands of judges and juries. And in the case of paternity suits, there were already judges like Le Bon Juge Magnier who would find ways of awarding child support to women, typically based on their claim that they had been seduced, even though it was illegal for them to get child support based on the claim that this was the child's father, which is sort of interesting to think about how you say that this guy, we have no idea if he's the father, but we know he seduced you, and therefore he has a responsibility for this child. It seems like fairly obvious that the missing link there is not so missing. And I thought about this also, work on women in the criminal justice system shows that although it was not legal for women to kill their male lovers in the way that it was for men to kill their wives, that women did often get off for throwing vitriol in their faithless lovers' faces, and other so-called crimes of passion.
Yeah.
That,
Ed Berenson talks about that a lot in his book.
Yeah, in his trial.
Yeah,
of
there-
But
Madame
I don't know, but
Joël
Vic,
Diaz.
yeah, I mean, Vicky's question is also, I think, about, are the cases, or is attention to the cases driving some of this attention? I think there's a tremendous amount of sort of sociological interest and criminological interest in what these cases are, and at the same time, a sense that that people could use the courts, for women's advantage, right? And that's what I think the legal education is doing, that the feminists are saying, we have to use these tools because we're stymied elsewhere. And then there's also the cultural perception of, we have all these social problems, we got to do something about it. How are we going to attend to it? And one idea that's, that I think is even sort of somewhat mainstream is, if you put women on the juries, you might get something else. You might get better enforcement. And I think for those people, it's not necessarily about the vote. Like, I don't actually think they think that way, but that you're going to get a better criminal justice system. It's more equitable, it's more effective if you put women there. And then the vote problem is like, well, I don't know. I'm going to have to figure out whether those sort of more conservative folks who support jury reform are also saying, well, there's this danger we might give women their rights. Oh my goodness. What that path is. Go ahead.
There's another piece too, the jury issue in particular with regard to convictions in all male jury, and that is the cases of infanticide, which Rachel has talked about, where all male juries were acquitting women who were charged with infanticide to the point where the law was changed to decriminalize that and abortion in order that those cases would be taken away from the juries and put in the hands of the judges in order to get more severe penalties. And this was also happening in this same period. So there's a shift in the actual administration of justice that takes place.
Judicial experts didn't trust jurors. So even as women are trying to move in, there's this other sort of the expertise level saying, you know what, we really actually don't want you to decide those things at all. And so that's when I was trying to talk about sort of the expertise element, that's what's going on. And it works. They do it.
They do it, yep.
Yeah, and I have no idea whether there are actually more cases or not. But now I would think of Karen's pioneering article on depopulation, nationalism, and feminism. Whatever cases there were more alarming to everybody because of the situation of the 1890s and 1900s, where you have the birth rate falling below the level that you need to replace the population, and all of those even themes that you've heard before take on a new urgency in that specific setting. I think it's not an accident that they keep coming back to abortion, infanticide, paternity suits, abortion, infanticide, paternity suits. They could be talking about divorces and inheritances, and there are 1,000 ways in which women were disadvantaged in French law, but I think, there's a reason why it's the horrible things that are happening to our French children that is what you always hear about.
Well, thank you. This was a wonderful.
Thank you, everyone.
Great question.